is an appeal in the matter of Westminster City Council and James Housing Residency, Chiltern Street Limited and another.
Yes, Mr. Hutchings.
May it please your lordships, I appear with Mr. Decker for the appellant in this matter. My learned friends, Mr. Elvin of King's Counsel and Mr. Morris appear for the respondents. I understand, and there have been communication with the court about this, that you have 3 bundles, including where required hard copies, but I do, on behalf of my instructing solicitor, apologise for the lateness of the hard copy of the authorities bundle.
It's all right.
I'm grateful.
Can I mention one bit of housekeeping?
Of course.
Mr. Hutchings. As I hope you would have expected, we have read the materials, particularly, of course, the judgment, the skeletons and the agreement and the authorities that we're pretty familiar with.
Yes.
I'm bound to say it strikes us, me and us generally, that this is a single point of construction.
Yes.
One well-established authority.
Yes.
And it feels like a case that doesn't need to be listed for more than a day. I don't know why it's listed for a day and a half.
Well, I need to sit down because I suggested a day, and that was the order according to the permission to appeal. And I think it's my learned friend's side of the court.
Well, I mean, if you're both content that this case will take a day, I mean, we're not going to go absolutely crazy if it goes over a day, but it doesn't feel like a case that needs to go over a day.
I think we merely gave the estimate that applied to the court below. But I'm more than content for it to take a day.
Excellent. That's what we will do.
Well, we've clarified that.
Thank you. That was less painful than I was expecting. That's good.
Well, I hope this is also less painful, although I don't rule out pain in the course of the hearing, never do. But I intend to stick to the structure of the submissions in my skeleton argument and to give you a roadmap, which is always mentally helpful. Firstly, I'll deal with the factual background, which will be very brief. Secondly, the provisions of the agreement. Thirdly, the principles of construction. And fourthly, my submissions on the construction of this clause, which will be broken down into 4 subheadings: natural meaning, context, scheme of the agreement, and commercial consequences. So, in my skeleton argument, if you have it, in the introduction, paragraph 3 sets out what the question is: whether the first respondent is a person deriving title through any mortgagee of a registered social provider within the meaning of subclause 10.1.1, and the outcome of the case depends on the answer to that question. The judge decided, which, as I referred to at paragraph 4, that the relevant exemption criteria meant a third party which acquires title by way of a disposition from a mortgagee whose mortgage was granted by a registered social provider. That's the date of mortgage construction. And he rejected the appellant's rival construction, which is date of disposition or date of disposal construction. We say he was wrong. This is a clear case where the natural meaning of the words in their contractual context is that it refers to the factual circumstances as at the date of disposition. And that's really the beginning and end of it all. Of course, you have to ride all the horses because it's multifactorial.
Sure.
But that's the main thrust of our case. So I then move on to the factual background, which I set out paragraph 9 of my skeleton, and it's common ground. It's not very complicated. Planning permission with 106 on the 11th of April 2013. It's got affordable housing obligations in it. I'll just give you, in case you want kind of easy references. So the section 106 is the core bundle 13.
Yep.
That goes against A. And then the Third party legal charge, if you need to look at it, is at supplementary bundle tab 5, that's letter C. D, the novation is supplementary bundle tab 6. And then the regulatory decisions are in the supplementary bundle 9 to 10 and 12 to 13. That corresponds to letter E. And then F, the default notice, is supplementary bundle tab 14. And the transfer to the first respondent, which is the material one, supplementary bundle tab 15. And that's really all you need to know. So I can then move on to the relevant provisions. So paragraph 14, I make the point, which is common ground, that the section 106 was negotiated between Howard Kennedy LLP on behalf of the developers and Borough Legal Services on behalf of the claimant, and I think it's always been common ground that it is a sophisticated and complex document entered into with benefit of skilled professional advice on both sides. So we can then move to the relevant provisions, which are in the core bundle behind tab 13. In some sense, it is the key document for the whole appeal. If I just take you through it to give you an introduction, so the definitions, relevant definitions begin on page 165. We've got in particular affordable housing and affordable housing units, which are relevant definitions. And you'll see the affordable housing means subsidised housing available through a registered social provider or other social providers the Director of Housing shall have approved in writing beforehand for this transaction. And affordable housing units obviously identifies the 16 AHUs and also makes clear there's 10 social rented units and 6 intermediate rented units. The next relevant definition is on page 170, which is the definition of registered social provider. We've got 2 limbs, the first being a registered provider of social housing as defined in Part 2 of the Housing and Regeneration Act 2008, or who is approved by the Council, such approval not to be unreasonably withheld or delayed. And you'll see this keys in, we've already seen a reference to that possible approval in the definition of affordable housing. So those are definitions. And then the...
Can I just go back to page 165?
Of course.
Definition of affordable housing. Picking up on the point you just mentioned, shall have approved in writing beforehand for this transaction.
Yes.
I think the judge says that the transaction refers to the grant of the leases to the RSP.
Yes, we'll see that in a moment.
Is that your understanding? That's how it works?
That's correct.
Thank you.
So then the it's logical perhaps to look at the affordable
So we're
housing
talking about the 1 to 5 year leases to
yes, at least 99 years.
Yes, thank you.
We're just about to look
Sorry.
at that. No, absolutely. You're ahead of the game.
Unusual.
I'm sure that's not at all true. But the affordable housing obligations are at Schedule 1, which contains the developer covenants. And the material ones are paragraph 11. They begin at the bottom of page 176. They're still in the core bundle. So it's not unfamiliar. No occupation of the market housing units until the affordable housing units have been completed. For transfer on a long lease of at least 99 years to a registered social provider. That's the first element of the answer to my Lord's question. Or other social provider as the Director of Housing shall have approved in writing beforehand for this transaction. So in that this transaction appears to be the transfer on a long lease of at least 99 years, the reference back. In 11.2 there's another reference to those two possibilities, subject to the RSP being willing to accept the grant of a long lease of at least 99 years to grant such lease to such bodies. There's an obligation to grant the lease to a registered social provider. And then 11.3, not subject to clause 9 above of this agreement and a paragraph 11.6 below this schedule to occupy the affordable housing units other than for affordable housing. So that's the key affordable housing obligation. The reference to clause 9 is a mistake. It refers to our clause, clause 10, exception, mortgagee exception clause and other exception clauses. Paragraph 11.6 we'll see in a moment. But this is a continuing obligation on the developer and its successors in title not to occupy the affordable housing units otherwise than as affordable housing, which we've seen means the housing has to be provided by a registered social provider throughout. We don't really need to worry about 11.4, 11.5 because they impose additional requirements in relation to the tenure of the social rented units and the intermediate rented units, which are not unexpected because those units have specific rent levels and regulatory requirements. And then 11.6, in the event that after a period of 12 months from the affordable housing units being ready for occupation, no registered or other approved social provider has taken a lease of all the affordable housing units in accordance with the provisions of paragraph 11.2 above, then the developer will be entitled to request relaxation and or variation and or deletion of the restrictions contained in paragraphs 11.3 and or 11.4 and or 11.5. It's one of the safety nets to which I refer in my skeleton. With that context, we then come on to the clause 10, the exceptions.
But, are you coming back to 11.6?
So,
Because it's linked into Schedule 2 of the Section 106, the Council's covenants, and at page 181, the point you just drawn attention to is picked up in paragraph 8.
yes,
If such a request is put by the developer, the council has to consider it acting reasonably. And
Yes.
then there's provision for an independent determination by an expert
yes,
appointed by the Law Society.
yes, so that's
And
a very good point.
consistent with the misnumbering of clauses in this document. The penultimate line refers to clause 8, but I think it's clause 9.
Yes, I accept all of that and thank you for highlighting that. So within that context, we then have clause 10, which in effect is an exceptions clause. And we are primarily interested in 10.1.1, which is any mortgagee of a registered social provider or any receiver appointed by such mortgagee or any person deriving title through any such mortgagee or receiver. So as I've alluded to, it's got two limbs. The first, via the definition of registered social provider, refers to the statutory definition in section 82, part 2 of the Housing and Regeneration Act 2008. That is in the authorities bundle at tab 2, page 14. Just so you can track down the the paper chase, which is often required. So it's really this, comes to this on page 14. Persons listed in the register may be referred to in an enactment or other instrument as registered providers of social housing and are referred to in this part as registered providers. So the register is the register of providers which is provided for under this Act, and persons listed in the register are referred to as registered providers. And just to provide a tiny bit of context for that, for the time being, on page 28, you'll see section 116 provides for voluntary registration, but subsection 4 provides that once entered in the register under this section, body remains registered unless and until removed under sections 118 or 119, which are mandatory and voluntary deregistration.
So the original social housing provider in this case was a voluntary.
Yes.
It fell within 116.
Yes.
Thank you.
Mandatory registration really was local authorities.
Thank
So I'll be corrected if I'm wrong, but for the private registered providers, it's voluntary.
And the same would apply to kinsmen, presumably.
Correct.
Yeah.
Both deregistration, both mandatory deregistration and voluntary deregistration are heavily regulated, if I may put it that way, as is this sector generally. So we're really, in terms of my skeleton, about paragraph 18. So you've got the statutory definition, then you've got the other alternative, which is approved in advance, which we've discussed, and we saw those provisions. So what I've tried to do at paragraph 19 is to incorporate into the clause the various elements into the relevant words that we're looking at, so that it becomes any person deriving title through any mortgagee of a person listed in the register of providers of social housing, so that's incorporating the statutory wording, or a provider of social housing approved by the Council's Director of Housing in writing beforehand for transfer of the affordable housing units on a long lease, and we might add, according to my Lord's comments, pursuant to Schedule 2, paragraph 8. So I think we all accept that the approval of an unregistered social housing provider would be the exception rather than the norm, because the local planning authority would much rather, in accordance with its planning policies, have social housing provided by a registered provider.
But there's a reason why it's in the agreement. Presumably it recognises the possibility, for whatever reason, that an RSP can't be obtained.
Yes, and in particular,
And rather than suffer the possibility of is it clause 11.6 issue, which could lead to the restrictions disappearing, the council might instead accept an unregistered social housing provider.
yes, I agree with all of that, and it caters in particular for the possible scenario in which there isn't sufficient lending for a registered provider to acquire the units. Because of one of the points that the respondents make against my date of disposition construction is that might restrict the lending available to a registered provider. And one of my answers to that is that this agreement already has safety valves for that scenario. The first being the potential or the discretion to approve an unregistered provider. And the second is 11.6, which is a process by which, if they haven't sold, well then the provisions can be relaxed, including an expert imposing that on the parties. So that's one of the reasons why I say that the commercial consequences, my learned friends point to, are unreal.
But we should bear in mind that the local housing authority wouldn't want either of those two events to come about if they could be avoided.
Agreed, the local planning authority, but yes.
There are tensions in this clause.
With respect, there are tensions all over the place. And this is one
tensions in this clause.
within this clause.
Because there are objectives which compete with each other.
I agree with that. I agree with
That's
that.
going to affect how parties will negotiate.
Yes, and it also means it's very difficult from a consideration of business common sense for the court to ascertain where along the negotiation line the parties actually reached an agreement. Otherwise, done by paying very careful attention to the wording of the clause. That's my basic submission. It's one of those cases where, and you'll see this, there's some evidence, everyone knows, developers and local planning authorities know that the developer would rather not have any of these restrictions, would rather have none at all, and the local planning authority, would, subject to actually being viable, would rather have as many as possible. So commercial common sense in a way doesn't get us very far. We have to look very carefully at the wording. That's my submission. It's Lord Hodges' point about the centre line of the tug of war rope. So I now move on to
At
principles.
the end of the day, the local planning authority would fear most of all losing the affordable housing rather than having affordable housing provided by an unregistered social housing provider.
Well, we know that discretion is in there,
Mm.
but that doesn't mean that they didn't go for their top aim or, one of their best aims in the primary obligation. The fact that there are the escape valves make that, if one's doing this kind of crystal ball gazing, what was in the reasonable commercial parties' minds exercise, they might well have pitched it higher because they knew there were escape valves. And at the end of the day, approving an unregistered provider isn't the end of the world. And when I say that, it's not just, council's imagination. We see that from the agreement. So, principles of construction. And I don't know if I'm reading too much into indications from the bench that you're wearily familiar with this territory.
I'd say I wouldn't use the word weary.
Enthusiastically familiar.
All enthusiastically familiar with.
Yes.
We'll try to find ways of writing judgments on construction which don't involve citing large chunks of old.
Well, perhaps I can help in that one. Perhaps I can help because, or rather, it's the Supreme Court that's helped. Because at tab 19, after the skeletons were prepared, I think, it might have come out days before the replacements. So tab 19 is the Supreme Court's decision in Providence Building Services Limited and Hexagon Housing Association Limited, which you probably know. It's about terminating a JCT design and build. The good news in my submission is at page 412. If one wants to start a judgment with a summary of the principles, this is the judgment of the Supreme Court delivered by Lord Burrows, at paragraphs 21 to 23. There you have it. nothing more need be said, perhaps. But as a summary, it's very helpful because it is the judgment of the Supreme Court. So, meaning of words, subjective and contextual approach, reference to ICLR, the meaning which the contract would convey to a reasonable person having all the relevant background knowledge, and business or commercial common sense may be relevant. But in Arnold and Britton, the Supreme Court clarified that the words used by the parties are of primary importance, so that one must be careful to avoid placing too much weight on business common sense or purpose at the expense of the words used. There we have the synthesis, really. It's about weight. But nevertheless, as explained in Wood and Capita, we do have this iterative process. And yes. So there is part of the reasoning in this case which may help you in the present case. So just to check you're familiar with the basic case, that appears from the head note 403. So it's a JCT design and build. This is about a contractor's notice of termination. And both, will not surprise you, both the employer and the contractor have a right of termination in certain circumstances, but there's a procedure for each to serve a default notice. So if there's a default notice not remedied, you'd expect the party to be able to terminate for a breach of the default notice. But what if then there's another breach after that default notice of a similar kind? Can the party go straight to termination or not? And the relevant provisions set out in Lord Borough's judgment, paragraph 5 on page 406. So we've got 8.9.3. This is all termination by contractor. 8.9.3 is the contractor may give to the employer a default notice in the circumstances. And then so that's 8.9.1.3. And then we've got 8.9.4 on page 407. If the contractor for any reason does not give the further notice referred to in 8.9.3, but whether previously repeated or not, the employer repeats the specified default, then they can terminate. So that's what the argument is about. But there was also reference as part of the context to the employer's right of termination. That's at paragraph 7, clause 8.4. So 8.4.3, if the contractor refuses or neglects to comply with a notice or instruction from the employer, etc., then over the page 408, the employer may give the contractor a notice specifying the defaults. And then there is provision point 3. If the employer does not give the further notice referred to in clause 8.4.2, but the contractor repeats the specified default, whether previously repeated or not, then upon or within a reasonable time after such repetition, the employer may, by notice to the contractor, terminate that employment. So there was quite a lot of argument about whether or not the termination provisions were symmetrical. And what I'm interested in is the reasoning of Lord Borough's, approved by the whole Supreme Court, paragraphs 36 to 37, which is on page 416. So Lord Boroughs makes the point that Lord Justice Stuart Smith placed great weight on clause 8.4, and that was the employer's right to terminate. But what appeared to drive his analysis, do you have that opposite letter C? In favour of the contractor was his conviction that because the structures of clauses 8.9 and 8.4 was the same, and the words of clauses 8.9.4 and 8.4.3 were so similar, the words in clauses 8.9.4 and 8.4.3 should be given the same meaning. And Lord Burroughs goes on to criticise such approach, paragraph 37, and said the heavy reliance on clause 8.4.3 is misplaced for three main reasons. And the third reason, which is between F and G, roughly in the middle, thirdly, different words were used by the drafter of the JCT standard form in clause 8.4.3 to those used in 8.9.4. 8. And so forth, it gives the details and carries on. Why use that different wording if the two clauses had the same meaning? Mr. Lewis submitted, and I agree, that the different wording is explicable precisely because it was being clarified in clause 8.4.3 in contrast to 8.9.4 that there need be no previously accrued right to terminate. So that is that reasoning is relevant in the present case because one of the respondents' arguments is that if you look at clause 10 generally in all those subclauses, they all refer to historical transactions. So this one should be construed in that way as well. And I say that's diametrically the wrong approach. The fact is, different words were used with a different intention.
Okay.
So I just wanted to pick up a couple of points in Arnold and Britton and Wood and Capita. I'll be quite brief about those. So in the Authorities Bundle, tab 13, Arnold and Britton, we have the parts flagged by the parties, pages 273. So there's paragraph 15 within Lord Neuberger's judgment, which is a kind of summary. And then he went on to emphasise some factors over the page. And 17 is the not to undervalue the importance of the language of the provision. And then 20, the court should be very slow to reject the natural meaning simply because it appears to be imprudent. And that really is what dictated the outcome in that case, paragraph 32 on page 277, unattractive consequences. But he's unconvinced because the lessee's construction involves departing from the natural meaning and it involves inserting words which are not there. And also, paragraph 37, Lord Neuberger, this is page 278, made a point about commercial risk. It ends with the vivid line, I have little doubt that many fortunes have both been made and lost, sometimes both by someone entering into, in essence, a risky contract. In other words, just because it involves risk doesn't mean that the court should strive to avoid the construction which exposes a party to a level of commercial risk, even quite a high level of commercial risk. And then in Wood and Capita, at tab 15, within Lord Hodges' judgment, you have paragraph 10, which is another summary. And then over the page 336, paragraph 13, textualism and contextualism, and it contains the statement, some agreements may be successfully interpreted principally by textual analysis, for example, because of their sophistication and complexity, because they have been negotiated and prepared with the assistance of skilled professionals. And then lastly, on the topic of commercial common sense, we also have BMA Special Opportunity Fund Limited, which is at tab 11. And I'm interested in the sideline part. If we begin at 237, under the heading Analysis, Lord Justice Aikens, paragraph 24. Says if there are two possible constructions of the document, a court is entitled, this is going over the page, to prefer the construction which is more consistent with business common sense, if it can be ascertained. However, I would agree with the statements of Mr. Justice Briggs in Jackson and Deere. First, commercial common sense is not to be elevated to an overriding criterion. Secondly, parties should not be subjected to the individual judge's own notions of what might be the sensible solution. I would add, still less should the issue of construction be determined by what seems like commercial common sense from the point of view of one of the parties to the contract.
Jackson and Deere went to the Court of Appeal and was overturned. as it happens.
Yes, but
Well,
that
because
doesn't detract from the authority of
the
this.
court hadn't given proper weight to commercial common sense, but
Nevertheless, this statement of principle appears to have some authority.
well, you would say that that's reflected in the other cases that you took us to.
Yes, it is. And paragraph 33, page 240. This is really, and so to make good point, the submission I've just made, I will refer back to Lord Hodge's tug of war. So here, Lord Justice Aikens is really making the tug of war point. Doubtless the lenders would have wanted a fee to be paid for prepayment in as many circumstances as possible. Doubtless they settled on a compromise. The ultimate position was the essence of commercial common sense. In other words, a compromise is the essence of commercial common sense, and that is reflected by what Lord Hodge said later. I should have referred you to this earlier when we looked at it. It's tab 15, page 339. So this is really about the extent of the liability under the warranties. And in a sense, the context doesn't really matter. But over the page on 340, business common sense is useful to ascertain the purpose of a provision and how it might operate in practice. But in the tug of war of commercial negotiation, business common sense can rarely assist the court in ascertaining on which side of the centre line marking on the tug of war rope lay when the negotiations ended. So that's hand in hand with the caution to be given to notions of commercial common sense, and is consistent with what Lord Justice Aikens said about a compromise which might involve risk for either or both parties is the essence of commercial common sense. So I now move on to my submissions about construction. My basic submission is that the natural reading of the relevant words is a straightforward factual description of the circumstances as at the date of disposition. And my analysis relies to an extent on the composite wording that I've produced by reading in the incorporated definitions at paragraph 19. And the first thing I do is I direct the court's attention to there are in fact two elements.
If I just question you about that,
Of course.
the way you formulated it.
Yeah.
Because you've tagged it on to the end bit of the clause, but not actually where it would naturally appear in
Yes,
the
there
clause.
there are more elements in this. I've tried to simplify, but I accept if you.
I mean, not where it would naturally come in if you were putting all of those words in is earlier in the clause, isn't it? Where it would come in after it would say any mortgagee of a, and then it would say have your words of a person listed in the register,
Agreed.
etc.
Agreed. So that's the first. If one wants to expand the whole thing, the first one is the mortgagee of a person listed in the register or proved in advance. And then the second is any receiver appointed by, and then we can have the same phrase, any mortgagee of a person listed in the register and so forth. And then the third is as my paragraph 19. So there are three elements in total. I've tried to simplify, just focus on our words, but I agree with you.
But the natural way of doing it would be the way they've done it in the drafting, which would be to put all those words in and then say of such mortgage receiver appointed by such mortgagee or
Yes.
person deriving title through such mortgagee. You wouldn't
Yes.
have to keep repeating them. So it would look rather different from your formulation.
Well, I'm only trying to be helpful. I think the point is one has to insert into, it helps to insert the definition of registered social provider in there when one's performing one's analysis. And that
Why does it help?
well, because it's a registered social provider is defined as a registered provider, which is a person listed in the register. That's that's lim A.
Yes. So why does it help to include the second limb of the definition in this agreement?
Well, because otherwise my learned friends will cry foul and say, well, I'm ignoring.
That wasn't the purpose of my question. No doubt they would. Why have the parties gone to the trouble of expanding the definition of RSP in this way?
To make clear that the requirement, which is not only an element of this clause, but it's the 11.3 obligation via the definition of affordable housing, which incorporates the definition of registered social provider. So it's a key concept.
So if I understand, it's to align with 11.3.
No, the reason why the parties...
Sorry, the definition of affordable housing.
The purpose is to make clear that the provider has to be listed in the register.
Yeah.
Because that's what the statutory definition means.
Yeah.
And this is a concept which is important in the Section 106 as affordable housing obligations as a whole. Because there's an obligation to ensure that the provider of the AHUs is a person listed in the register throughout. So I say that you can analyse that requirement, a mortgagee of a person listed in the register, into two elements. One is there has to be a relationship of mortgage between the mortgagee and the person. And the second is the person has to be listed in the register or approved in advance. The respondents accept that paragraph 36 of their skeleton argument that clause 10.1.1 plainly contemplates a disposal by a mortgagee exercising its security. They accept that the relationship of mortgage has to subsist as at the date of the disposition. Yet they say that the words listed in the register applies to a different date, although it's all part of the same phrase. So I say in substance the respondents accept that mortgagee of a person refers to an ongoing relationship, not an historical transaction. And that is directly logically inconsistent with their case on construction. They try to wriggle out of it by saying, well, that's just implicit. I say it's not implicit, it's express. That's what the words mean. By contrast, so I picked this up, this is kind of paragraphs 31, 32, 33. By contrast, on the judge's construction, what it meant was that London District Housing Association was registered on the 19th of August 2015. Therefore, this was a person deriving title from a mortgagee of a person listed in the register. Because it was when the original mortgage was granted 8 years previously, the grantor of the mortgage was London District Housing Association, which was registered. And I do say that it's just very unlikely that a reasonable person reading this clause would interpret it in that way. There's another inconsistency in my learned friend's submissions, which keys in with the point that my Lord Justice Miles fairly put to me, that you also have to bear in mind so there's the mortgagee, then there's the receiver, and then there's a person deriving title. So they're actually, it's bigger, much bigger than what I said in an attempt to simplify. So my own friends submit in their skeleton argument, paragraph 38, that the reference to a receiver appointed by such mortgagee requires that the provider be registered as at the date of the appointment of the receiver. That's what they submit, paragraph 38 of their skeleton. Well, that's not a date of mortgage construction either. And it helps me, because what they're saying is that the relevant time for asking the question is when the receiver is appointed. And that's directly analogous to my submission, that the relevant time for asking the question is when the person derives title. So, if you like, there's the first bit, any mortgagee of a registered social provider. The respondents accept it has to be a registered social provider at the time this clause is being enforced. It's ambulatory. And then any receiver appointed by any such mortgagee, the respondents also accept it's ambulatory and refers to the date of the appointment of the receiver. And yet they refuse to accept the logical corollary, which is that person deriving title through any such mortgagee or receiver refers to the date of deriving title.
If the judge's construction is correct,
Yes.
why should the social housing provider have to be registered at the time when the receiver is appointed? Why are
Yes,
they
it's
right-
inconsistent.
Why are they right to make that point?
Why are they right to make that?
If the judge's construction is correct.
If the judge's construction is correct, then it's not right. It must follow that it's just the date of the mortgage and that's it. But the fact they make that submission is because that is the natural reading of the clause. They've kind of given the game away a bit. And I have, one can get bogged down in all the technical twists and turns, and it's sometimes helpful just to ask yourself a simple question. So if it said, any person deriving title through any mortgagee of a 5-star hotel, well, if the hotel's been regraded to a 4-star hotel, and you ask the question, is that any person deriving title through a mortgagee of a 5-star hotel? The answer is no. And that's, I know it's not.
It depends, doesn't it? I mean, that's, it might do. You might read it the other way.
I don't know. My submission is the natural reading. If you just ask that question, any person deriving title from a mortgagee of a 5-star hotel, you're looking, it naturally means the time you derive title. Unless you want to add something.
Isn't that partly, if just taking that as
out of context.
accepting it, that's because you changed the grammar from referring to a person to referring to a thing by saying a 5-star hotel rather than a provider.
So any person deriving title from a person registered as a 5-star hotel, I say the answer is the same. It doesn't make any difference. So my submission is that is the natural meaning.
Let me just ask you this. Supposing that the mortgagee forecloses on the mortgage on the 1st of January, and then to, let's say, 2026, and then on the 1st of January, so he gets complete title, and then 2 years later, on the 1st of January 2028, he sells it, or 10 years later. The person who acquires it has derived title through the mortgagee, but the mortgage doesn't even exist at that stage. It's been foreclosed. How does that case work? Part of your argument was there has to be a subsisting relationship of mortgagor and mortgagee, but on the wording, the purchaser has derived title through the mortgagee, and the mortgagee has itself got full title by foreclosing.
So your example suggests that it's actually the date the mortgagee enforces.
Not necessarily.
No, that's one potential answer.
But there's nothing in the clause that suggests that ties one to a date of enforcement by the mortgagee.
No, that's just context. Well, I suppose my submission is that the person wouldn't, on a natural reading, that person wouldn't derive title, would derive title through a mortgagee of a registered social provider. That would be the, in my submission, instinctive reaction to that, because for all relevant purposes, the mortgagee was a mortgagee of a registered social provider. But you're making the point that that wouldn't necessarily be right up to the date of the disposition, but it certainly would be up, or in my submission, should be up until the date the mortgagee, in your example, obtained its title, enforced its security. I think that's the best answer I can give to that question, which is an unusual, I mean, foreclosure is unusual. So I next move on to context. So if one looks at 10.1.2, there is another exclusion, the thrust of which is to facilitate lending to social housing tenants acquiring the affordable housing units. In particular, there's a right to acquire under Section 180 of the Housing and Regeneration Act 2008. So any mortgagee of a residential tenant or person to whom a registered social provider grants a lease or transfer, etc. So the idea behind this is that the mortgagee of a tenant acquiring their home is exempt. But it's interesting, the wording used here is a person to whom a registered social provider grants a lease or transfer. So my point is, the respondent's construction of 10.1.1 accepted by the judge amounts to a mortgagee to whom a registered social provider grants a mortgage, or a person to whom a registered social provider grants a mortgage. That phrase clearly focuses on the date of the grant of the lease or transfer. And the requirement is the provider's got to be registered on that date. So given the draftsman knew how to express this concept, why did he not, I ask rhetorically, say in 10.1.1, any person to whom a registered social provider grants a mortgage? That would be making clear the respondent's date of mortgage construction. And the fact that he knew how to express such a concept, but did not use those words in 10.1.1, in my submission, is telling.
Is the upshot of your approach to construction that if we go back to 10.1.1 and the opening words, they're to be understood as any mortgagee of a registered social provider gets the benefit of this exemption for so long as the social housing provider remains an
Listed on
RSP?
the which is what the statute provides, yeah. The
Well,
person listed in the
the
register.
statute is obviously dealing with something different. We're dealing with the construction of the opening words. But the way you're reading it is to say this exemption applies to a mortgagee of an RSP on condition that the
From time to time.
on condition that the RSP remains registered.
But I don't accept its reading in a condition in my submissions. When it says,
on the so long as, if you
Yeah,
prefer.
I prefer saying listed in the register from time to time.
But it has to be read that way when we come to the second part of the clause. If the receiver part of the clause is going to be dependent upon the the RSP being registered at that time of
Yes.
appointment. So this approach goes back to the opening words and how you understand them,
Yes.
and dependent upon the answer to that question. So the answer colours the rest of the clause, doesn't it?
Yes. And the point I'm on is, why not say, and I'm banging the same drum, but why did the draftsman not say a person to whom a registered social provider grants a mortgage? He knows how to say it. That's what the respondents say he meant.
Well, the second clause is dealing with something different, isn't it?
It is.
Isn't it saying the use of the word to whom, the phrase to whom a registered social provider grants a lease or transfer? It's not really making a temporal point, it might be thought. It's just defining the class of persons. It's saying mortgagee of a residential tenant or person to whom the RSP grants lease or transfer. So it's defining the persons who are within the clause. But mortgagee is just a person to whom a mortgage is granted, and that's the same phrase as is used in clause 10.1.1.
Well,
It
first of all,
doesn't say here, it doesn't use the word to whom a mortgage is granted. It's defining the persons by reference to a lease or transfer. And it just uses the same word, mortgagee, meaning the person to whom a mortgage is being granted.
but that accepts the respondent's case that different words were used, but they, in essence, had the same intended effect. You say that any mortgagee, or you're putting to me, that any mortgagee of a registered social provider is synonymous with a person to whom a registered social provider grants a mortgage. And my point is, one, no, I don't accept that. My submission, it includes any mortgagee of a person listed in the register. And I say the natural reading of that is from time to time. And
Or alternatively, at any time when an RSP is registered.
yes,
So it's effectively reading in words.
and I don't accept that. I say listed in the register is enough. The question is about the time at which you ask the question. And I say it's ambulatory. And there's nothing to fix this as at the date of the mortgage. I accept it defines the class of people excluded, but it does by reference to a concept, person listed in the register, the status which varies over time. So there is necessarily a question, what time? And that, in essence, is the question for you. That is it. I also say that the time at which the exemption is applied is significant, because it can only be applied from the perspective of after the mortgagee has disposed of the title to the third party, my limb. So the vantage point is that the local planning authority will be looking at it from a perspective of after the disposition. And that is significant, Because when you look at it from the perspective of after the disposition, you ask yourself, did that person derive title through a mortgagee of a registered social provider? Looking at it from that vantage point, the natural answer is no, because by the date of the disposition, they were deregistered. And lastly, in terms of natural,
Just on that for a second.
yes,
Looking at it that way, doesn't that mean that a mortgagee, or construction of the first bit,
yes,
would mean that a mortgagee of the registered social provider, they've got the mortgage, which they negotiated with someone who was at the time they negotiated with
Yes.
the registered social provider,
yes.
and had the consequences that it would have. But then those consequences then disappear, that the mortgagee can do nothing about. They stop being registered.
What in fact
The
happened?
mortgage itself can change, the value of it can change
The value of it can change because the value is reliant
on your construction.
on this exception clause. Yes, that's right. And I'll deal with this when I come on to commercial consequences.
Okay.
So I just wanted to deal briefly with the scheme of the agreement. So
Just before you do that,
Yes.
sorry, how do you deal with how does it work with a registered social provider in capitals who's never actually registered? Because it's someone who has been approved,
yes,
but as an unregistered
yes.
and approved by the council.
Well, they're approved in advance at the time of the long lease, or in advance of the long lease. So they're the exception which proves the rule. Completely different wording. It's clear that that approval is approval in advance.
But how's
So
that then
they're
is
in
a
the
case
exception.
where the person is never registered and yet the mortgagee is exempted?
Yes, absolutely. That's what the words provide for, my lord. And as I explained at the outset, the local planning authority's top aim is they want to have a registered provider, which is therefore regulated, providing this housing throughout, in perpetuity, preferably, if possible. But there are several escape valves within the Section 106 itself. The first is that they can approve an unregistered provider. And if they do that, they're approved throughout, and the mortgagee gets the benefit of this exclusion clause throughout. I accept that.
So the mortgagee knows where he stands in that
In
situation.
the outset, yes.
But in the case where it's a registered social provider, i.e. genuinely a registered person, the mortgagee will never know whether his security has any value.
That's an exaggeration of, I think what...
All right, will have the value which he thought it had.
There's a possibility that it might not have the value it thought it had. That's a fair way of putting it. And that's commercial consequences.
Right,
And
sorry,
I know I have to address that.
I've jumped ahead.
I know.
Just forgive me, just since we're on it, just to be absolutely clear, I've got the point. You're accepting that if in the case of the unregistered social provider, who's by definition in this contract a registered provider, if the local authority then decided disapproved of them in some way in future, which no doubt happens in the real world, that would have no consequences.
There's no provision for that in the agreement. It's what the parties agreed.
Sure, no, I get it.
Yeah. Yeah. Well,
So this
So it's a once and for all approval.
it is. I agree with that. But my
Doesn't
basic...
that then colour the approach to be taken to the concept of a mortgagee of an RSP? Why can't that be?
Well, essentially for the same reason that Lord Burroughs gave in the Providence Building Society. You have different words, have different effects.
Yeah.
And the parties intend them to have different effects. That's why they use different words. So I accept...
Yeah, but there's a need for logic as well. One can see the words are different, but the question is whether they're being deployed to different purpose, different
Well,
effect.
I say there's nothing illogical about having, and perhaps we're already in the scheme, there's nothing illogical about the agreement providing for the top level, which we know that the requirement is that the top level is a registered provider providing the housing throughout. And that is a condition for benefiting from this exclusion clause if the mortgagee is exercising its power of sale. Right? But then I think the way that I'll put it to me was that you then might have a negotiation in the context of 11.6, which is if there are no takers for the affordable housing units on those terms, then the developer can say, look, you need to relax all this stuff, make it much more favourable to me, or else it's not going to sell, and I'll go to expert determination if you don't agree. So then there's this negotiation, and the local planning authority has the fallback of saying, all right, find me a reputable provider that's not registered but has access to lending on better terms, and I'll approve it. And it's kind of a midway. So in my submission, there's nothing, it's not about perfect logic. There's nothing uncommercial about having 3 levels like that.
Well, you would say it's a compromise.
It's a compromise. And what they mean is you can only derive according to their terms. It doesn't have to satisfy perfect logic. The judges might think the perfect logical solution is X, but that is not business, the cut and thrust of business. The other point I make is that the respondents at various points have placed reliance on this root of title submission. Oh, that's what it naturally means. Well, maybe to property lawyers, but root of title is actually a concept of unregistered conveyancing, and rather old-fashioned now. I say that doesn't help at all. This is a public document on a planning register. It's available to be read and understood by ordinary people.
Just before we move on,
Yes,
still
of
on
course.
the agreement, we've rather looked at clause 10 in the context of one part of Schedule 1, namely the affordable housing obligation.
Yes.
But the mortgagee is bound by the whole of Schedule 1, subject to the exclusion.
Yes.
And on one reading, on the judge's reading of the way clause 10 works, is I'm a mortgagee and I'm granting a mortgage to an RSP, and they're an RSP at that point in time. I then have the benefit of the exemption clause 10, one would have thought, on an ongoing basis.
Well, except that if one looks in practice at the various obligations in Schedule 1, it's only really when you're talking about someone providing lending to the provider of the affordable housing units, the only thing left is going to be 11.
Well, there's an affordable housing contribution of £4 million. What if that's not paid? That's more than the amount they lent in this case of 3 million.
So where does your logic
Well,
find?
I'm looking at this quickly, but
Yes, but
but affordable housing contribution is defined on page 3 as just over 4 million. There are also other contributions.
yes,
Education
but that's
contribution.
the development.
How does that work?
If you look at 175,
Yeah.
in practice, that's clearly going to be the developer's shout, because he can't commence development till he's paid all those sums. 1, 2, 3, 4. So all that's going to be done before the mortgagee takes his mortgage. All those sums will be paid.
Okay.
So it's not unsurprisingly that wouldn't be a burden placed on such a mortgagee. So shall I move on to the scheme? Yeah. So I think I just need to show you some parts of the Housing and Regeneration Act 2008. So that's in the authorities bundle, tab 2. So the register is provided for begins on, so it's chapter 3, the register starts on page 18. So you have 110, and then page 19, 111, the regulator maintains a register of providers of social housing, and it's public register. And then 112 is the eligibility criteria, so that's on page 20. We don't need to worry about anything up until 116, page 28, about registration, and subsection 4 we looked at. Once entered on the register, body remains registered unless and until removed. So that's my point, that it's inherent in the concept of a person listed on the register that it's from time to time they may be deregistered. And 118 is deregistration. And there is a right of appeal from a deregistration, mandatory deregistration decision. And 119 on page 34 is deregistration, voluntary, which is you have to meet certain criteria as specified in subsection 2. And usually that means that the social housing has to be preserved. So the point I make is that in the case of an ordinary mortgage default, there's a continuing obligation on the developers and their successors entitled to make the affordable housing available through a registered provider. That means one registered at the time, from time to time. That's paragraph 11.3. The effect of that is that the provider is regulated under Part 2 of the Housing Regeneration Act 2008 on a continuing basis. And that is obviously desirable from the local planning authority's point of view. The functions of the regulator have to be performed with a view to achieving the regulatory objectives, which are set out in section 92K. It's on page 16. I should say that my own friends made the point in their skeleton we should be looking at the historical legislation, so we are.
Yeah, we're told from this print that they've all been superseded.
Yes, so we're looking at the statute at the time of section 106.
Yeah.
So 92K, fundamental objectives.
So what was the page reference again?
Sorry, page 16 in the authorities.
Right.
So it's the economic regulation objective and the consumer regulation objective. It goes on to define the economic regulation objective. B, to support the provision of social housing sufficient to meet reasonable demands, including by encouraging and promoting private investment in social housing. So it's part of the fundamental objectives of the regulator. So the way that clause 10.1.1 normally works is that the lender or receiver has a right to sell the affordable housing units at open market value. That's what 10.1.1 is doing. But before exercising the power of sale or appointing a receiver, the lender must first notify the regulator of its intention to do so. And we find that a little further on at page 40. So, yeah. Section 144, this is the legislation as it was at the time, and my skeleton refers to the current, but in a footnote to the legislation at the time. There's no material difference, but we're looking correctly at the legislation as at the time. So section 144 provided that steps specified in the table has effect only if the person specified has given the regulator notice. And the first type of step prescribed, and any step of kind prescribed for the purposes of this section by the Secretary of State by order to enforce a security over land held by a private registered provider. And one has to read that with the 2010 order behind tab 3. So any step to enforce security over land held by a registered provider shall be a prescribed step. That's what the 2010 order provided on page 73.
So if a registered provider is deregistered prior to the taking of a step to enforce, the moratorium provisions don't apply.
You've leapt ahead to the end of all this, but I don't. So again, you're well ahead of me. So the point I'm making at the moment is that in an ordinary case, so let's take financial default. The provider's still registered. The lender has the right to sell at open market value, but first, before doing so, they have to serve the notice on the regulator, and that triggers the moratorium, which we see in the legislation at the time on page 42. 1451. So the step triggers the moratorium. And then 146 on page 44. There's a moratorium that lasts, subsection 2, it lasts for 28 days, unless it's extended under subsection 3, which requires the consent of the secured creditors.
Can I just make sure I understand this? Because 144 has the words at the beginning, a step specified in the table has effect only if
Yes.
the person, and then when I turn to 145, we have a very similar table to that which you see in 144. If a step specified in the table is taken, the moratorium begins, and then there's an obligation to serve in the subsection 2 to give the regulator notice as soon as reasonably practicable. Just trying to understand how when I read this for the first time, I didn't quite see how these two provisions tied up. It may not matter, but indeed, 3, if the notice is not given, the step is not invalidated. It's not very easy to...
It's not very, it's not terrifically easy to reconcile those two provisions.
I mean, speaking for myself, subsection 1 says the moratorium starts when you take the step. It's not about when you've notified, it's when you take the step. Step 2 is about when you notify. So the moratorium. So if you've taken the step, the moratorium will have started, and you're supposed to give notice as soon as you can. And step 3 says if you haven't given notice, then the step is not invalidated, but the end of the moratorium depends on when you give notice.
Potentially applies forever
So
until
if you
you give
don't
notice.
if you don't give notice, the moratorium will apply forever.
Yeah.
That's what I think.
Yes, but what I have a little bit, I follow that, but 1453, I don't quite see how it ties up with 144 opening words.
No,
The step has effect only if.
I
It
agree.
sounds like validity.
I agree with you.
It looks like overdrafting, but
I suppose, Juliana, if one, there's a more specific provision at 146. Well, what else can one do apart from rely on Latin maxims to dig one out of a hole? I don't know.
sorry I asked.
I don't know why that was so funny, whether you both sat on a case that involves that principle.
No, this is
recently.
a neat move.
Very nicely done.
Flick of the ball.
So one of the points is 147. So once the moratorium ends and a further step is taken within 3 years, that there isn't a further, there's no automatic further moratorium. So the point is that if this does key in or tie in to the way that 10.1.1 works, in the sense that it's the first step the lender takes to enforce the security. So if the lender appoints a receiver, that triggers the moratorium. If the receiver then enforces, that doesn't trigger a further moratorium. If the mortgagee exercises the power of sale and simply sells, well, that's the enforcement route for the lender directly. So the 10.1.1 and the various ways in which they operate dovetail with the statutory scheme in the sense that on my construction, the provider has to be registered when the receiver's appointed. That ensures appointment of the receiver triggers the moratorium. What happens afterwards, no interest, because the job's done in terms of the scheme and the statutory moratorium. But if the lender merely enforces the power of sale without appointing a receiver, it's the date of the enforcement of the power of the sale which is crucial in terms of triggering the moratorium. What the local planning authority would like to see is that the provider remains registered up until the point of enforcement. And this may key in with the point that my Lord Justice Miles put to me, that actually if you think about some situations like foreclosure, it has to be the date of enforcement. That's my only credible ambulatory construction. And I would say that would tie in with the way the statutory moratorium works. What the local planning authority doesn't want to see is that the provider becomes deregistered before the moratorium is triggered. And so I need to just say a little bit more about the moratorium. So page 48 within tab 2 of the authorities, the effect of the moratorium, subsection 2, during the moratorium, a disposal of the registered provider's land requires the regulator's prior consent. And then there are exempted disposals in section 149, page 50. Then we've got section 150 on page 51. A purported disposal by a registered provider is void if it requires consent. The regulator has not given consent. And then we've got various powers which the regulator enjoys during the moratorium. Got section 151, interim manager. Section 152 on page 53. The regulator can make proposals, in essence, to all interested parties about the future ownership and management of the registered provider's land with a view to ensuring the property will be properly managed by a registered provider. And then on page 54, section 153 provides for the procedure, consultation, sending copies of the proposals, in particular to secured creditors. Subsection 4 is important. It provides if each secured creditor to whom proposals were sent agrees by notice, the proposals have effect. And pursuant to section 154 on page 56.
So presumably, if they don't agree, it doesn't have effect.
Correct. Yeah.
So is this right that, sort of simplifying enormously, the secure creditor can't, as it were, be forced to agree a new registered provider?
Correct. It's power persuasion. And
There's a moratorium which stops it from taking steps for the relevant period, but it can't be required to say, okay, I'll become the mortgagee of somebody else.
no, you can't, the regulator cannot require that. My basic submission about this is that experience shows that the moratorium is actually quite a powerful tool, and that one should bear in mind that persuasion from the regulator of a sector that you invest in may be persuasive on a lender. And you've seen that in exercising the regulator's powers, they have to have regard to the need to encourage private lending into the sector.
The moratorium lasts for 28 days.
Yes.
There is a provision for its extension.
Yes, but again, the secured creditors have to agree to that.
Yeah, which provision is that?
147, my lord.
Thank you.
Thank you very much.
Or 146, is it?
147, my lord. The extension.
No, but
Sorry, further moratorium.
so I think it's 146(3), isn't it?
Yeah, but 147
Yes, 146 subsection 3.
Sorry.
No, thanks for trying to help through the thicket. It's 146(3)
Thank you.
on page 44. So there is some background material at tab 21 about how it works in practice. So in the authorities, we've got a Trowes and Hamlin's article, which is about insolvency in the social housing sector. So on page 424, the authors who specialise in this area discuss some of the considerations which you've really been raising. You know, that the moratorium isn't a panacea, and the authors say the regulator does not have carte blanche to impose its proposals. It also makes the point that these situations don't arise out of the blue, and it's likely the regulator will have been aware.
Ah, so this, and I'm on 424, just at the bottom of the red line, sidelining. It's because of the shortcomings in the 2008 Act that amendments were introduced in the 2016 statute to introduce the concept of housing administration.
Yes, it was because
So
it was.
presumably that has more teeth.
It does have more teeth, and that was enacted in response to a particular crisis in relation to a large registered provider. What the
I
authors...
mean, does the housing administration regime enable the views of secured creditors to be overridden?
In certain circumstances, yes. But the authors conclude on page 425 there hasn't been a single housing administration.
Well, it may be the very existence of the regime
Yeah.
is
No, I
enough
take
to
that
secure the result.
I take that.
Whereas previously that regime didn't exist, and that was
The-
the context in
the
which
gen-
the agreement was negotiated.
I completely accept that. But the general picture is you've got a regulated sector that's generally very stable. There are very few insolvencies. And the regulator does have a power of persuasion to persuade even secured creditors to accept an outcome which is beneficial for the sector.
Deregistration presumably can happen for a variety of reasons. One could be to do with the financial standing of the association,
Yes.
but it could be the way they're running their housing estate.
It's being mismanaged.
It's managed.
Yes. So my point is about, in terms of the scheme of the way that the agreement interacts with the statutory scheme, is that in a normal case of mortgage default, there is a safety net, whether it's not an absolute panacea, but it is an important feature from the local planning authority's point of view, provided the provider is registered up until the point of enforcement of the security. The local planning authority has the advantage of the moratorium and the regulator stepping in. And that the respondent's construction creates a lacuna in the case of a deregistration. The moratorium doesn't apply. So I say that this is something which
Is that a lacuna in, where's that lacuna? In the statute or in the, where is the lacuna?
the lacuna is in the scheme of the agreement as it normally operates in conjunction with a statute.
I think what you're saying, the lacuna is simply that if, once you get to deregistration, the moratorium provisions aren't engaged at all.
Agreed.
Not sure I call that a lacuna, it's just the way the
Isn't that
statute
just a
operates.
consequence of the statute? That it only applies to registered providers?
But my construction of the agreement means, in essence, that lacuna can't happen, because if they're deregistered before enforcement, then the lender can only sell at social housing value.
I mean, I can see
Well,
that's
subject-
your argument.
subject to the
I'm
obligations.
just struggling a bit
So-
with the idea that there's a lacuna here. It's just, isn't that just the consequence of the legal background against which the agreement is entered?
I mean, it's criticising the other side's construction because of a lacuna in the statute, actually, which was remedied by the 2016 Act.
No, that lacuna wasn't remedied. That's not what I'm criticising.
That's beefing up the moratorium provisions.
Yeah, they say it's not worth it anyway, and I say be real. In fact, the regulator intervening in these situations often does save social housing assets, and that's what the local planning authority would like to happen if there is a mortgage default. So that's the commercial consequences from the local planning authority's perspective. They want the date of enforcement, if I'm modifying my submissions in line with questions from the date of enforcement construction. They want that because that's more beneficial. It keeps the moratorium, it has to apply. Then the respondents say, well, hold on, this means that the lender's going to be caught in a trap. And I say that's not realistic. All the lender has to do, well, first of all, the process of deregistering a registered provider, as the facts of this case show, doesn't happen overnight. It takes months, if not years. Secondly, regulatory notices are published. So the lender's going to know all about it. All a responsible lender has to do is to notify the regulator, I intend to enforce my security when they get deregistered. What are you going to do about it? Then the regulator has both matters before it, and it has to decide what the solution is. I say, given that it's one of the fundamental objectives of the regulator to encourage lending in the social housing sector, there's no way they're going to say, oh, I'm just going to deregister and you can be left without your full security. It just wouldn't happen. So my submission is unreal. A responsible lender has a remedy, which is you notify the regulator early on that you're intending to enforce your security.
Well, before it's deregistered.
Yes, absolutely.
But supposing that it just happens, you haven't done that, it's been deregistered, what do you then do? You're not obliged to notify the regulator under the Act as the lender, because it's not a registered provider.
Correct. So it depends which construction is right. On my construction, in effect, the lender is forced to notify the regulator at an early stage.
Would the mortgagee necessarily know?
Yes. I mean, it's unreal.
Why is that?
It's a public process. It's published on the register. You're an investor in the social housing sector.
Sorry, what's published?
The regulatory decisions of the regulator.
Prior to deregistration?
Yes. Should we look at them?
No, you can just explain it.
Yes. So the regulator of social housing produces either regulatory judgments or regulatory notices, and they're published. They usually issue a press release whenever they're investigating or examining any particular registered providers. And then in the present case, there was something like 4 published decisions before it actually got deregistered.
Right.
And that's my submission, that's the reality. So I understand the point. There is, in theory, a trap here for the lender. I just say it's not real.
I'm sorry to be slow.
No, I'm sure it's...
But what is the incentive on the lender to notify the regulator that they're thinking of enforcing the security?
On my construction, if they just sit back and allow the registered provider to be deregistered, they're stuck with social housing value.
Yes. So
they don't want that.
How are they better off by telling the regulator at an earlier stage?
Well, because the regulator's in charge of deregistration, and they say, hang on, there's the interest.
That's not going to affect whether the regulator deregisters or not, because he's
Yes,
got
it
an
is,
independent statutory duty. He's not there to look after the interests of lenders. Isn't the other way of looking at this to say that as a lender, rather than take the risk of deregistration, you'd be more inclined to enforce your security earlier rather than later?
That's what the respondents say.
So what do you say
I
to
understand.
that?
My point to that is that triggers the moratorium.
Which has the effect which you've helpfully shown us.
Yes, which usually results in a solution. But you know, the local planning authority doesn't get anything more out of it than the moratorium. That's all they can get out of this type of agreement. But if the respondents are right about the construction of this provision, they don't get the moratorium. But I don't agree with the point you were just putting to me, that it's not going to have any effect, because so first of all, there's two obvious points.
Sorry, you can.
Can I just finish this, do this
Sorry,
point?
I'm
Then,
so sorry to interrupt.
not at all, not at all. So page 32, section 118. The regulator may remove from the register. There's a discretion. And there's quite a lot of statutory guidance about, you know, enforcement. It's got to be proportionate and all the rest. And I showed you 92K fundamental objectives, page 16. regulator must perform its functions, including the 118 deregistration function, with a view to achieving, so far as possible. It includes B, to support the provision of social housing sufficient to meet reasonable demands, including by encouraging and promoting private investment in social housing. So I say they do have a remedy. Any responsible lender in the social housing sector, when they saw this coming down the road, would be engaging actively with the regulator. They'd say, look, under our section 106, we're going to be stuck without getting our money back. It's not going to be in accordance with your fundamental objective. So whatever you do, don't deregister them before we've enforced our security. The regulator says, fine, I am going to deregister them, but I'll give you some time to enforce your security. That's the solution in my submission.
Why would the regulator do that? Surely the regulator would say the opposite and say, and then you'd end up with more social housing than not.
No, because well, you're not going to encourage lending in the social housing sector if the lenders don't get their money. Don't get their money. That's the bottom line,
Well,
and that's the way.
that's actually the regulator helping out the lenders.
Yeah, that's what it
In
says
a
they should do.
specific case.
No, I don't have a case, and they wouldn't.
No, sorry. In this specific case, it's saying
It's scenario.
we can see you've got this problem with your contract. We're gonna hold off doing what we would otherwise do to put you in a better position. Is that realistic?
Yes, it is. My submission is you have to view this agreement in the statutory context, and that's what it is.
Yes, but I was going to ask you, where do we find language in section 118 or elsewhere which would authorise the regulator to behave in that way?
Well, because they have a discretion.
Well, I thought that's really your point, it's a
Yeah.
discretion, but the discretion is basic Padfield principle, it's got to be exercised for the statutory purpose, so one just reformulates the same question, where is it a statutory purpose for the regulator to have regard to assisting lenders to recover their loans?
92k, my lord.
But isn't that, yeah, okay. That's not just the position of the regulated body. Well, is it? Is it subsection 2A?
2B.
Well, within 2A to ensure that registered providers are financially viable. But B, as you say, is wider than that.
Well, B is directly encouraging, promoting private investment.
Yeah.
So, I mean, look, but this is not surprising. The regulator's there to look after the well-being of the sector, and that includes lenders. It's just that when you're lending in this sector, it's rather different from an ordinary commercial market, that you are lending in a regulated sector. And if you have an issue, you go to the regulator and they sort it out. And so my submission is that the date of enforcement construction means that the local planning authority always gets its moratorium. And that means it goes before the regulator. And that is a solution. It doesn't ride roughshod over the secured creditors, but it is a potential solution to save the social housing assets. And it's not a trap.
Forgive me, the point about it always getting its moratorium is only on one half of the way this contract is constructed, because it depends on it being a real registered social provider as defined as a registered
Yeah,
social
no, there's
provider.
always the exception which proves the rule. I agree with that. Yeah, and so when the local planning authority is considering whether to approve an unregistered provider, it knows it's not getting a regulated provider.
But the point I'm alluding to is that the clause, doing a consequentialist reading of the clause, which is only talking about the clause on certain ways, certain parts of the clause, not the whole clause.
I agree, but there are the different wording achieves different results. And my point is that, as I say, you've got these three levels, which are all catered for by the 106. The top level is, this is a regulated provider throughout. And that has the benefit of the moratorium. I say my construction is consistent with that. And then the next level is, well, we're going to approve them in advance, because obviously the developer couldn't find a registered provider that was willing to take them on. And that's better than the final level, which is the expert releases or adjusts these affordable housing restrictions. And I say that my construction is perfectly consistent with that overall interpretation of the way this works commercially. I think the respondents make a bad point, paragraph 44 of their skeleton, that you need the date of mortgage construction to encourage a new provider to be able to come in and take the social housing assets off the hands of the soon-to-be deregistered provider or deregistered provider. That's not right, because the new registered provider coming in with lending, the mortgagee will benefit from 10.1.1 on its own rights. So that's just a bad point. So I think I've really addressed you on the commercial consequences. You were pushing me there, and I think we've probably got there.
Just one very detailed point, sorry. You
No.
mentioned, I know it probably doesn't arise, but you mentioned this new administration procedure.
Yes.
And one question would be just helpful to know the answer. Does that apply only to registered providers?
All the regulatory scheme only provides to registered providers.
So actually the bolstering of the moratorium, if we call it that, isn't helped. It doesn't bolster it for this situation.
No, I'm reliant on the same submissions I make in terms of. Hold on.
The lacuna that you've mentioned is that seems to arise from the fact that the moratorium provisions don't apply to a deregistered provider. And I suppose, and you mentioned the new administration provisions as beefing things up, but
Yes.
they may not actually beef it up if they also don't apply in the case of a deregistered provider.
No, they don't. So my point is, on the respondent's construction, if you've got a deregistration, the moratorium need never be triggered, and that's whether in its less beefy form or its more beefy form. It just never doesn't get triggered in this scenario.
Right.
That's my basic point. And their basic point is, well, this is a trap for an unwary lender, and I say that's just not real.
Yeah.
I think that's it. They do also make a point about there being some kind of inconsistency between the date of the appointment of the receiver being critical, as we both seem to accept, and the date of disposition or date of enforcement in relation to non-receiver enforcement of the security. And my answer to that, I answered that at paragraph 61M of my skeleton. And I addressed you on it in orally. The point is, on my interpretation of how the scheme works, it makes sense that the provider has to be registered up until the point of appointment of the receiver. Because as long as that's the case, appointment of the receiver triggers the moratorium. What happens after that, never mind. So I say that point is a bad point, and on my construction, it all dovetails with the statutory moratorium. Oh, I should just show you this. For what it's worth, within the authorities, there's an article from Inside Housing, tab 20. There's an article from Inside Housing. Because obviously you're considering what would reasonable commercial parties have had in mind in terms of commercial consequences in 2013? This is an article published in 2008 about mortgagee exclusion clauses. And in some ways, it kind of makes the point, Lord Hodges' point about, well, the range of, whatever one wants in it being a compromise. So 419, preference of the bank is an unqualified exclusion clause. Then it refers to what was becoming a common practice to include a contractual moratorium. Then in 419 it refers to the preference of local authority would be not to have any exclusion clause. They want the affordable housing stock to be required and provided in perpetuity. And then the final part on page 420 makes the point, before the mortgagee of a social landlord can enforce its security, there's a 28-day moratorium, while the housing corporation, as it then was, decides what to do with the distressed landlord, including considering the possibility of a transfer of engagements to an alternative social landlord. The moratorium can and is likely to be extended and does provide protection for the public purse and social housing stock, as has been shown in the case of the Virginia Housing Association. One could argue that a further delay imposed by an agreement is unnecessary, but that approach only works if the provider is actually registered up until the point of enforcement. So it's a hypothetical negotiation, but it has some realism, because all contracting parties knew that the moratorium was a feature of the landscape and how that interacted with the contractual scheme would have been in reasonable hypothetical parties' minds.
But the upshot is that when we're looking at the application of the moratorium in the context of dealing with a lender, secured lender, for the moratorium to apply at the time when the default event takes place and the security is going to be enforced, the housing provider, the social housing provider, must be registered.
Yes, in order for the local planning authority to have the benefit of the moratorium, they have to be registered at that time.
You would have thought that if that was so important to a local authority, they'd want to make that clear in the clause excluding liability.
Well, I think it was Lord Neuberger, possibly as Mr. Justin, who made the point. It's rarely helpful to say the parties could have been clearer.
I understand all that, but it seems rather obvious.
Well, in my submission, it's clear enough.
Well,
that's what it means.
Basis that we read the reference to all the way through the clause, including the receivership provision, it's all got to be read on the basis that the exclusion applies if at the time,
from time to time,
the social housing provider is registered.
Yes. I think it might be common ground that it has to apply on the date of appointment of a receiver. So that was.
Well, you've said that before. I for my part only, I query that because it depends on, and as you accepted, on reading this, what might be called constraint, in from the opening words of the provision. I appreciate if you can, then all the rest follows, arguably.
Yes, but I don't accept it's reading anything in.
No, I understand that.
Well, if it said a disposal by a registered social provider, then in my submission it would be absolutely obvious that meant they had to be registered at the date of disposal. Okay, so it's the context. So I say that 10.1.1 refers to two events: appointment of receiver and deriving title. I think the point that's been put against me is that It's not actually deriving title, it's my construction, it's enforcement of the security. The other side accept that the entire premise of this is enforcing the security, and there has to be a relationship with mortgage as at the date of enforcement. My submission is this means that the provider has to be registered as at the time of enforcement. And that's implicit. And if that's right, and that's what the ordinary natural meaning and context, particularly contrasted to some of the other clauses which refer to historical transactions, then it dovetails with the statutory moratorium. The local planning authority basically always gets the benefit of the statutory moratorium, which is something they would want.
So effectively, we're imagining lenders who are prepared to lend on this regime, on this basis, that they will only be able to enforce their security if, at the relevant time, the social landlord is registered.
Yes.
As a quid pro quo for the local authority being able to enforce the moratorium regime with all its limitations.
Well, the proof's in the pudding. I mean, you know, lenders came forward. Unfortunately, it appears they weren't the most reputable ones. That's by the by, in a sense. But in terms of construing the agreement, as I say, if no providers are prepared to come forward on these terms, the agreement provides for that. So there's no commercial reason to construe this as being especially lenient on lenders, because there are other provisions in the agreement which allow that to be relaxed if they don't come forward on these terms. So unless I can assist you, I think those are my submissions.
Thank you very much. Yes.
May it please the court. My learned friend Mr. Morris will deal with one specific issue, which is the point that you were discussing with my learned friend earlier about the incentive on the mortgagee and its relationship with the Registrar of Social Housing. What I think we refer to, or the judge may refer to, as a perverse incentive resulting from Westminster's construction.
Okay.
But I'll leave that to
Sure.
Mr. Morris to deal with that.
Very good.
I'm not going to trouble the court with references to authority. The court is well familiar with the authorities and they're set out in our skeleton in any event. My submission, as you will be aware from our skeleton argument and from the judgment, is that the reference to a mortgagee of a registered an RSP is an indication of the status of the mortgagee at the entry into the mortgage. And to pick up my Lord Justice Miles' point at an earlier stage, when looking at, say, 10.1.2, what you're looking at is something which is descriptive of the person who has created the security. And it's not a temporal issue at all, it is simply a description of fact. And that is determined, whether one calls it root of title, it doesn't really matter. The point is the mortgage is created at a time when the person who is taking the loan and securing it against its interest is a registered provider. The fly in the ointment for my learned friend's submission as to the natural meaning of the words is the fact that he persistently seeks to dodge, which is the fact that it doesn't have to be a registered provider, and the court is now very familiar with the provisions of the agreement. The definition of affordable housing allows it to be an approved social provider which is not registered. So perhaps simply to go back to the agreement. The definition of affordable housing, page 165, it could be other social provider. The definition of registered social provider at page 170 also brings in or person who's approved by the council, such approval not to be unreasonably withheld or delayed. That particular aspect is also reflected in clause 11.1, which specifically refers to the approval of an unregistered social provider, and indeed 11.6. So it's a common theme throughout the Section 106 agreement that the affordable housing units could be secured by an approved but not registered social provider. And there was no evidence before the court below. I mean, there were factual witness statements, but don't go to this point at all, as to the reason for the inclusion of that. It simply has to be derived from the provisions in the agreement. There's nothing much other than the statutory context by way of extrinsic evidence to the extent it would be admissible anyway. But there's no evidence as to the reason for that inclusion. What is clear from the inclusion of that, it is inherent in the definition of registered provider, because the words my learned friend seeks to read into clause 10.1.1 in my submission go nowhere, because they are restating what is obvious from the definitions in the agreement. And you've got to factor in that the provider of a mortgagee may be of a registered or an unregistered provider. And whether one terms it a condition, as my Lord Justice Holgate suggested, or some other language, that it should be the status according to Westminster should be continuing up to the date of the disposition from which the person derives title.
Well, he said it could be from time to time.
Well, on any view, it reads in words that are not there, and as he says, carefully drafted between legal parties and a very experienced, as my lords will be aware, planning authority. And it doesn't work in the case of the unregistered social provider, whose presence is part and parcel of this agreement. The learned friend cannot explain, other than by trying to say, well, it may be exceptional, why this is present and how it operates within his approach. Because to pick up my Lord Justice Holgate's point, it creates an illogicality within the operation of the same subclause if you treat the issue of the status of the mortgagee, other than simply as mortgagee, as ambulatory, because it simply can't apply to the other unregistered social provider. And therefore gives you a clear indication as to whether or not it was intended to be ambulatory generally, or whether it was simply, as I submitted earlier, an indication of status at the date of the creation of the security. Because all that the learned friend says simply cannot apply, neither the statutory context of the moratorium, the registrar of social housing and the like. None of that can be relevant to an other social provider.
So for the unregistered social provider, you simply look to see whether you're the mortgagee of such an entity at the date of the mortgage.
Indeed.
And that then affects the receiver limb and the third
Yes.
limb. That's your submission.
Indeed. And the difficulties, if you take it as meaning, having an ambulatory meaning, is that is not within the provision. And also it does create questions in in relation to the receiver, and indeed 10.1.2, if it is anything other than a factual descriptor. Is it Westminster's case, therefore, if the provisions are ambulatory, that someone deriving title from a receiver from a registered social provider also falls into the trap of deregistration, removing the exemption? It creates an issue which doesn't.
I'm falling behind. What's the position for a receiver in a registered situation?
Sorry, 10.1.2, this is the mortgagee of a residential tenant.
Sorry, right.
Who then may appoint a receiver and then dispose of it. In my submission, if the provisions are meant to be ambulatory because of the need to retain social housing, which appears to be Westminster's position, does the ambulatory nature catch the disposal by the receiver of the tenant at a time when the registered provider has ceased to be registered? all of this indicates in my submission, one doesn't need to go there because it is a description of status or the nature of the person or institution, not of a point in time. And indeed, if you take the simple case of the receiver in 10.1.1 rather than the receiver of a subsidiary under a subsidiary interest, is the receiver's position compromised if registration is terminated before the receivership is terminated? Because as the court will know, receivers under duties to deal with the property and to dispose of it if that is necessary to discharge his duties. Does that then become encumbered because the registered provider has ceased to be registered? As I've submitted, these issues simply do not arise, and the complications themselves seem to indicate that this is not what these provisions were intended to do.
You seem to be accepting in that formulation that at the time the receiver is appointed, the provider has to be registered. Is that?
Well, I'm sorry, my lord, I understand your lordship's point. I don't.
But also, Mr. Hutchings pointed out that you seem to have accepted that in your skeleton. Is that right?
I don't think it is accepted. Clearly, if the receiver were the receiver of a registered social provider and Westminster's construction is right, those problems arise. If we're right, then the issue is dealt with simply by the receiver having been appointed by the mortgagee, and that is sufficient to protect the receiver and the receiver's transactions.
Well, in my simple mind, I had thought the position had become clearer. The rival constructions start off with the opening words.
Yes.
And whichever view you take of the opening words then colours the two other limbs.
I'm sorry, my lord, I'm explaining in an overcomplicated way that exactly the same point.
But on that basis, if the respondent was conceding, as my lord pointed out in the skeleton, that in 10.1.1 a receiver, that limb could only apply if the social housing provider was registered at the time of appointment, that would not be consistent.
No, I accept
And
that.
if you did concede that, you're not conceding
I'm
it
not.
now.
I'm not conceding it. What I'm trying to grapple with the consequences of Westminster's arguments rather than our position is a simple one. Was the mortgagee of a registered social provider at the time the mortgage was created, and that is not a factual matter in factual dispute. Just on the factual issues, it is also worth noting that the attempt by the successful attempt, I hope, by the mortgagee to enforce its security was made only shortly before deregistration. You haven't been shown the documents, but it's in the supplementary bundle. You can see the notice of default and the intention to exercise the power of sale is set out at tab 14 of the supplementary bundle, page 126. And that ties it to an event of default in the charge, which ties back to an event of default in the loan agreement, which includes the threat of deregistration.
Sorry, so therefore...
Sorry, I'm sorry, it was slightly out of
Okay.
I was just reminding myself that the facts hadn't been fully explained, but the position is that the mortgagee gave notice
in this case.
On the 27th of August 2023. Of course, at the time that the notice was given, the mortgagee was still the mortgagee of a registered social provider, just ceased to be by the time of the exercise of the power of sale in February of 2024. But again, those factual issues are not in dispute. Our submission is based, as I've said, on the status of the mortgagee at the time of grant. That is consistent, we say, with the way the other exemption provisions in clause 10 operate, and that is the root of our submission about the natural and ordinary meaning of the words, bearing in mind that my learned friend seeks to create an additional tension to the normal tension between planning authority and developer by seeking to treat registered social provider in its registered form as meaning one thing, as having one effect, i.e. ambulatory, and other social provider, which is also defined as registered social provider by the agreement, as having a different consequence. And that, in my submission, isn't a natural and ordinary meaning of the provisions when you read them in the context of the definitions that I've taken you to in clause 1.1 of the agreement and in paragraph 10 of schedule 1. The commercial context, or the...
I mean, if you have an unregistered social provider, there is, as we've been shown, it's been expressed as a positive obligation to use the premises, but in fact it's expressed in negative terms.
Yes.
But the premises, subject to that, are to be used for affordable housing, which is then defined in terms of the types of affordable housing units and the tenure.
Indeed, but the question is whether Schedule 1 applies at all. That only applies if Schedule 1 is applicable to the mortgagee.
Attention please, attention please. A fire has been reported in the building. Please leave the building immediately by the nearest exit. Do not use the lifts.
I'm afraid we better.
Well, I suppose
That's a
better
short
10 to 1 than...
Rather like France against
Attention,
Iraq,
please.
adjourned for the
Attention, please.
thunderstorms.
A fire has been reported in the building.
Shall we adjourn?
Please leave the building immediately by the nearest exit. Do not use the lifts. Attention please, attention please. A fire has been reported in the building.